Hello everyone. This is the fourth and final installment of our quick tour of administrative law. Let's jump in. Previously on the regulators, we already talked about the where question, where regulators are in an institutional and in their institutional context. And we've discussed who the regulators are. And we've already begun the question of what do they do. We've already covered the rulemaking function of agencies, that is, the agency acting like a quasi-legislature. So now we're going to talk about the agency doing executive branch work, like police and prosecutors. They're watching for violations and they're building their case for the violation. And the agency does some judicial work. They resolve disputes with parties who don't agree that they've violated the law, or parties who have applied for some benefit and the agency denies them that benefit. So the agency acts sort of like a quasi-judge or quasi-judicial function. So those are the what questions we're going to be answering here. Agencies collect information in two major settings. First of all, they collect information about regulatory targets. In this setting, you could think of the regulators sort of like the police department. There are already existing rules out there, and some of them are built into statutes. Some of them are embodied in the rules that the agency itself wrote and promulgated. But now somebody's got to go out there and make sure that the relevant parties are following it. And so, for instance, with mines, there are lots of rules about how you make mining safe for the workers. And the Mine Safety Health Administration sends inspectors out into the field to go into the mines and make sure that the right equipment is in place and that the mines are following the rules. Similarly for OSHA, the Occupational Safety and Health Administration, they send inspectors out to various employers to make sure that the employers are following the rules. Lots of different agencies have their field staff out looking around, making sure that the safety and health rules that are in place are being followed. And if they're not, then the agency will start some kind of enforcement proceedings that would punish the target for, the regulated party for failing to follow the rules. One of the main local government functions involved here would be health inspectors. So, whenever you go to the restaurant and you see the inspection score, you know that a regulator has been around collecting information about the restaurant or whatever the other establishment is. Now, I've talked about the enforcement function of these collectors of information, the field inspectors who put together the case against somebody who's failing to follow the law. But there are also forward-looking functions that flow from this collection of information. So think of the Nuclear Regulatory Commission. If it's gathering information about how nuclear plants in the United States are the same as Japanese nuclear power plants or different from nuclear power plants in Japan, that might help the NRC create forward-looking rules that would prevent future accidents or disasters based on what we're learning about the design of Japanese reactors in light of disasters there. So the collecting of information may be backward-looking for enforcement, or it may be forward-looking to inform the legislative function of the agency. In another of its capacities, the agency collects information by waiting for people to come to them. This often happens when the agency's job is to administer a benefits program, the Social Security disability claims, or student loans, or immigration benefits of some kind or another. In these settings, very often the agency just establishes an office, tries to make itself accessible, but then people come to them asking for benefits. And as these people come in, then the agency collects information and then makes some ruling on whether the claimant is eligible or not for the benefit that they're asking for from government. I've mentioned immigration. We all do this when it comes to driver's licenses. This is a very commonly encountered function of government, but it's part of the executive branch collection of information function. The agency collects its information, develops its own view about what happened out in the world. Maybe the agency concludes, yeah, that employer was operating an unsafe workplace, was violating the rules. Or on the other hand, maybe this claimant does not deserve disability benefits, you don't meet the criteria, or you don't deserve the immigration status, you don't meet the criteria. What happens if the other party disagrees and says, no, wait a minute, I was running a safe workplace, or yes, I qualify for a visa, or whatever the claim is. What happens when the agency and the private party disagree? Well, then we don't just flip a coin, we try to resolve the dispute through something that looks like an adjudication, a trial. Except it's really interesting, it happens initially within the agency. So the agency pays some people to go out and collect information. They're the field inspectors. They pay some people to put together their cases. That's the counsel's office, the lawyers. And then they pay some people to function as judges within the agency to, at least initially, adjudicate any disputes between the private parties and the agency, whether it be the regulatory beneficiaries or the regulatory targets. Who are these agency employees who decide the disputes? They're not federal judges in the classic sense of judges appointed under Article 3 of the Constitution with life tenure. Instead, these are sometimes called AJs, that is administrative judges, or ALJs, administrative law judges. Statutorily, the ALJs have more protections of their independence. Their salaries can't be reduced. Their work can't be evaluated by somebody who's also bringing the charges, acting as a litigant in front of them. So there are various neutrality protections built into the statutes. But ALJs, AJs, they are the employees within the agency that resolve these disputes. They handle huge volumes of cases. So you see here a graphic dealing with the high volume immigration adjudication system. Some of these relate to claims of asylum, and some of them relate to other claims of immigration benefits. But you see that the immigration judges stay very busy. This is just one example of an internal agency adjudication process. And finally, if the party is not satisfied, they can end up appealing the agency's decision outside the agency to some life tenured Article 3 judge. The chart here explains how it's happening. So initially you get the field officer who makes the first determination. Yes, I think you were violating the rules, employer. You didn't have a fire extinguisher around, or you didn't have a guardrail there, and people could fall to their death from your second floor. And the employer disagrees and says, no, I wasn't violating the rules. I didn't, it was only a tiny little gap in the rail, or, I was following the rules for some reason. And so you go to some internal judge within the agency, whether it be an ALJ or an AJ, and the government lawyer presents the government agency's position. The employer, or whoever the disputing party is, presents its position, and the judge decides. If the judge decides against the private party, then that party can appeal up to the top of the agency. The folks who create the rules and otherwise set the policy can take that hat off and become appeals judges and can hear the case for themselves to decide whether the evidence is there to support it and whether this basic rule that the agency is trying to enforce is consistent with its overall policy. So you get a final agency decision. But at that point, if the parties are dissatisfied, then off you go to the federal courthouse, to the U.S. Circuit Court of Appeals, the intermediate set of courts in the country, but they hear the administrative law disputes as the first federal judges to hear it, and so they hear a lot of these disputes about whether the private party really has violated the law, or disputes about whether a claimant really is entitled to disability payments or immigration benefits or whatever the government benefit is. Now, in addition to hearing these appeals from the internal agency adjudications, the Court of Appeals also will very often hear challenges to the validity of the agency's underlying rules. So if a party believes that the agency failed to follow proper notice and comment process, ultimately, when the agency's about to enforce the rule against private parties, you can challenge the validity of the rule, take them to federal court and say, Judge, we want you to throw the rule out, invalidate the rule because they didn't follow the proper process, and make the agency start over from the beginning. The judge might agree, and then the agency could no longer enforce that rule. It's invalid, and they have to start from the beginning and try again. In addition, the parties might say they followed the proper process. They did notice and they did comment, but they just were ignoring the science. They were misinterpreting the studies or were otherwise acting contrary to the weight of the evidence that's out there, available from the scientific community. If the court agrees that the agency put a rule out there that was not well grounded in the available science, allowing for all the uncertainty that necessarily attaches to scientific studies, that if the court reaches that conclusion, it can again invalidate the rule and declare that it is, quote, arbitrary and capricious, or as an administrative lawyer would say, A and C, arbitrary and capricious, and on that basis tell the agency, you got to start over again, and this time you need to think more carefully about some of the gaps in your scientific knowledge or some of the contrary studies that cut against the policy that you're adopting. So that agencies are always doing their work with the idea that the court is looking over their shoulder. They're always doing their work with the idea that somebody, if enough dollars are at stake, will ultimately challenge their work, and a judge might overturn them. That being said, the agency wins a lot more than they lose in the court, whether it be challenges to rules or challenges to their internal adjudications. Agencies win most of these. But there is always this risk, and it shapes the behavior of the agencies. They're trying to avoid being reversed later on.